Hi, my name is Arthur Hardy Doubleday, and I'm the founding attorney at Doubleday Law. I would like to talk to you today about fighting an eviction in Massachusetts. So you've come home and you've received maybe a handwritten note or some sort of formal letter um, asking you to vacate your apartment. Um, in Massachusetts, eviction law, it has to proceed under summary process, and often landlords don't start that process correctly. So the first thing to do when you see that notice is to get in contact with legal counsel so you can make sure that your landlord is proceeding correctly. Um, Another thing you need to know is that tenants in the Commonwealth are allowed a number of defenses, and many landlords aren't prepared for those defenses. So the number one thing to remember is if you receive a notice asking you to leave your apartment, you need to be proactive. There are three types of notices you might receive: 14-day notice for non-payment of rent, 30-day notice um, for a no-fault eviction. That means maybe the house is being sold and the seller wants to convey the house empty, and an at-fault eviction, which is the landlord's asserting that you somehow broke the terms of the lease. All of these notices have technical requirements, and oftentimes I find defects in these notices, which helps to knock out the eviction for my clients. There are a number of defenses that a tenant can assert in the Commonwealth. One we just covered, not receiving the proper notice. Two is retaliation. Oftentimes retaliation comes up when a tenant has reported some sort of health code violation, and within a 6-month period of time, the landlord starts the eviction process. And a good example of this is you report to the landlord that the heat has been turned off, and then 3 months later, your landlord tries to evict you. He may be or she may be deemed to be retaliating against you in direct consideration of you reporting that the heat was not on. Third is discrimination. This comes up often with people with some sort of disability, where the tenant has asked the landlord to accommodate that disability, and the landlord has refused. When you're being asked to leave your apartment through the legal process, you, as a tenant, can assert a number of counterclaims. One is bad conditions, so that's where maybe your apartment's not up to code. I've seen everything from holes in the roof to rodent infestation to chip paint and lead law violations. Um, Also, you can assert a counterclaim under the Massachusetts security deposit law. Many landlords routinely violate this law, which gives tenants leverage to countersue them when the landlord's trying to evict them. Interference with the tenant's use of the home, which is really about a landlord maybe entering the home without notice, or a landlord changing the locks and not informing the landlord, not informing the tenant. Um, Landlords are strictly forbidden from self-help remedies in the Commonwealth, and as a tenant, you can countersue your landlord. And then last, if your landlord owns more than one apartment in the Commonwealth, that landlord may be deemed to be in the business or trade of renting and leasing housing, which means that they are subject to the Massachusetts Consumer Protection Law. So if they're found in violation of any of the above conditions or areas, you can sue for triple damages plus attorney's fees. And what that gets to is giving the tenant leverage to work out some sort of mediation or solution in the end. So if the landlord's suing you to get you out because you missed 1 month's rent, but the landlord owes you triple damages under the Massachusetts security deposit law, you can use the fact that your landlord owes you more than what you actually owe your landlord. And if it goes through full litigation, the judge will award you possession. But if it doesn't, hopefully we can recover some money back from you for you, and you can remain in possession without it being fully litigated. So fighting the eviction in court, your landlord needs to file in district or housing court. once you receive the summons, you should file your answer within 7 days. Uh, with all my clients, no matter what the situation is, I automatically motion for discovery. That postpones the trial date by 2 weeks and gives us time to figure out the proper defenses and counterclaims, and how we can prove that in court. If your landlord has filed in, let's say, Boston Housing Court, likely the trial date will be well into the future because that housing court is overwhelmed, and that gives us more than enough time to figure out a good defense and countersuit against your landlord. So the next step would be to get in contact with me. My name is Arthur Doubleday, and I'd love to talk to you about your issues with your landlord. My office is located at 45 Prospect Street in Central Square. You can email me at arthur@doubledaylaw, or you can give me a call, 508-789-7011, and I look forward to working with you on your legal matter.